Okay, so as promised, let's get stuck in and we'll talk about the duties to the court. So what I've tried to identify on the slide here is kind of an overview map of what the key duties to the court are and how they play out, so on a practical level. So again, I'm probably going to look at the slide here, so I'm sorry about this going sideways. So practitioners must prepare their cases properly, know the relevant laws and legal processes. That means that they need to check the primary sources. So that can be actually really fundamentally important here, that when you're actually in front of the court, you need to actually have the case law from the primary source, and you also have to have, if it's available, of course, the authorised judgments with you. So just pulling open your copy of Del Pont, going to the footnote and saying, waha, here is the authority for that proposition, quite frankly, might be a pretty good exam technique if you're desperate, but it's not going to work in front of a judge. You also have an obligation as when you're assisting the court to keep your knowledge up to date. And Copeland and Smith, again, the footnote here in relation to that requirement. So that means that if there is a change to the law, even if that change to the law, or if you've come across something that you weren't aware of until you got to the courthouse steps, and it turns out that it is not in your client's interest, your duty is to make sure that the court is informed about that precedent, about that change, about that regulation, even if it's not in your client's best interest to do so. If your client would be in a much better position if nobody knew about that particular law. So that includes, when assisting the court, clarifying misapprehensions. We don't clarify misrepresentations, we just don't misrepresent. And one of the things that we'll talk about in a little bit more detail is this requirement to use the process responsibly. So again, on the slide there, I've got references to what the rules are. I'm going to annoy at least one of you now with an animation that's going to cover up some of that slide. But I think in relation to misapprehensions, really make sure that you have a good understanding of Rule 19. It requires that you do not deceive or knowingly or recklessly mislead the court. I would suggest that it is reckless to go to court without doing the research. Similarly for an exam, to be perfectly frank. And your obligation to keep knowledge up to date. It's worth noting that the uniform rules don't specifically refer to competence in the context of your obligations before the court, but competence itself is one of those fundamental duties. So again, have a look at Rule 4.1.3 in relation to that. The key case in relation to the obligations of lawyers and the duty to the court in particular in the context of proper administration of justice is Giannarelli, I hope I'm saying that name correctly, and Wraith, a 1998 High Court decision. And again, the emphasis is mine here with a quote from Justice Mason taken from the case. The peculiar feature of counsel's responsibility is that they owe a duty to the court as well as to their client. Their duty to the client is subject to their overriding duty to the court. He goes on to say that performance by counsel of their paramount duty to the court will require them to act in a variety of ways to the possible disadvantage of the client. Counsel must not mislead the court, cast unjustifiable aspersions on any party or witness, or withhold documents or authorities which detract from the client's case. And if they note an irregularity in the conduct of a criminal trial, they need to take the point up at the time so it can be remedied, rather than keeping the point up their sleeve as a ground for appeal. Proper administration of justice depends on lawyers exercising independent judgment in the conduct and the management of their cases. So That doesn't mean that you're required to slavishly follow the instructions of the clients, though. So if you make a submission which is inarguable or reasonably open, you could be sanctioned for wasting the court's time. So in Giannarelli and Wraith, ultimately the court said that the council needs to have an eye not only to succeeding, but to the speedy and efficient administration of justice, and selecting and limiting the number of witnesses, deciding how many questions to ask, which topics or points of law to raise. Basically, the council needs to make sure that they're not wasting the court's time. Again, quoting from the judgment, notwithstanding that the client might wish to chase every rabbit down every burrow. So we're going to come back to this case as well when we look at advocates' immunity, which probably suggests that this is one that you should pay particular attention to. So one of the issues that comes up when we're thinking about the duty to the court is really that potential for the conflict of the two duties. So a conflict to arise between needing to zealously act for one's client, but also to maintain responsibility of the court. And it is very clear that when we think about the hierarchy of duties, the responsibility of the court comes first. In the preamble to the Advocacy and Litigation Rules, the Law Council of Australia presents a kind of discussion, I guess, regarding the conduct expected of practitioners in filling their duty to the court. And I'm going to quote from it here. Practitioners in all their dealings with the court, whether those dealings involve the obtaining and presentation of evidence, the preparation and filing of documents, instructing an advocate, or appearing as an advocate, practitioners need to act with competence, honesty, and candour. Practitioners should be frank in their responses and disclosures to the court and diligence in their observance of the undertakings which they give to the court or their opponents. So I'm hoping you're seeing now how the duties that we were talking about last week, in fact, or in the last lot of lectures, because I think they're in this week actually, how they all come together. So in what were the model rules, which have now effectively become the Australian Solicitors Conduct Rules, or part of the Uniform Law, have a look at 17.2, which prohibits which actually requires, I should say, disregarding instructions in some respects, essentially saying that they will not constitute a breach of duty to the client if they're done to further the efficient administration of justice. Rule 27.1 prohibits lawyers from being witnesses in cases that they are trying. Rule 27.2 says that if it becomes apparent that a lawyer will be called as a witness, then an associate can take over unless that would prejudice the administration of justice altogether. So it'd be good for you to think about the rationale behind those prohibitions. Because it's a really good way of thinking about how the conflict can arise. If you know something as a person who has had a long-standing relationship with a client that could help the client, it's in your client's best interest for that evidence to be provided. Then how do you juggle that with your duty to the court to remain independent, or the other way around? If it's likely that you have information, think back to Nicola Gobbo and the witness X prosecution. If you have evidence that you might be called on to give that needs to clearly be excluded under one of the exclusions from client confidential information, but is contrary to the client's interest, can you actually continue to be involved in the matter at all? I think by putting these into context, you get a much better ability to grapple with what the law is. And ultimately, this is all about revisiting this idea of independence, and kind of asking yourself, well, what do you do if you don't actually believe your client? What do you do if the client has confessed to you and they still want to plead not guilty? Now, I asked you to watch a video about an American circumstance that dealt with that some weeks ago, but these, while rare questions, particularly the second, they're not unfathomable questions. The proper administration of justice really depends on lawyers exercising independent judgment when they're conducting and managing cases. And so lawyers need to remain alert to the importance of fulfilling that duty of candour that they owe to the court. And this can involve bringing caution, even skepticism, to a client's narrative. The lawyers need to take reasonable steps to verify the things that the clients tell them, their contentions, especially if the allegations that are made against them are serious. We all want our clients to be honest. We all want our clients to be the good guys, but that doesn't always happen. And even though it's rarely the stuff of movies or television series, good lawyers are making sure that the guilty are well represented, and that they're afforded the benefits of a justice system that requires proof beyond a reasonable doubt. And there is a difficult road for those lawyers, particularly in the criminal justice system, that need to navigate those boundaries, but they're an incredibly important set of boundaries that really make our system work. So, as I mentioned before, lawyers are not required to slavishly follow the instructions of their clients. So what do you do if a client demands that you mislead the court by either by documents that you present or by some other means? Ultimately, the safest course of action is likely to be withdrawing from acting. And for authority for that proposition, have a look at Vernon and Bosley, a 1999 Queen's Bench decision. Also have a look at Del Pont and Conduct Rule 19.3, which make it pretty clear that if you have to withdraw because you've essentially provided false documents, that you have a duty to correcting the record about primary legal materials, but it doesn't go as far as to correcting errors in the evidence that opponents have provided. So in relation to false documents, so for example, affidavits that you end up you learn at some point have been perjured, so they contain false information. If you learn that, then you cannot submit those documents. Kyle and the Legal Practice LPCC 1999 case is really authority for this position. It's worth noting, though, that if pleadings are kind of a grey area. Normally you can't amend pleadings without a client's permission. And again, Del Pont is really useful on this particular point. This is one of the reasons why it's important that you try and verify allegations that clients make, particularly if the allegations made against them are serious. No, you don't have an obligation to withdraw if you find that the allegations that your client made are false. But again, Del Pont is going to tell you that it's a really, really good idea. And we'll talk a little bit more about ex parte applications in a little while as well. So actually, let's put that to one side. But Conduct Rule 19.4 will help you with ex parte positions. I think the other thing about thinking about this from a point of view of independence is you really need to think about whether you should act or not, particularly in a litigation sense. If you have a personal or a business relationship with a client or with the opposing counsel, because objectivity and independence could end up at risk. Again, take a look at Del Pont in Chapter 17. Will really help with that. And again, I really like some of the real-world examples that Parker and Evans give with their kind of case studies in relation to that personal relationship. And we've talked previously about situations where lawyers who've had sexual or romantic relationships with the people that they're acting for, how that has really been difficult, it led to ethical difficulties for them. In criminal cases in particular, having a relationship with a client, a close personal relationship, can lead to the lawyer becoming a party to a wrongful conduct, or ultimately relate in some kind of misleading of the court or wasting the court's time. They're the things that you really need to look out for. In-house lawyers have in some cases been found to have not had the requisite professional detachment in cases that have involved their employers. So Henderson Borough Council and Auckland Regional Authority is a 1984 New Zealand case which had that position. Del Pont seems to be in the view that this may no longer be the case, and it's not really an issue that I've seen come up particularly, but it's definitely worth thinking about when allegations are serious, whether your relationship is too close. So as I've mentioned a few times, that the duty of candour is really fundamental to this idea of the duty to the court. A lawyer's duty to the court to obey the law requires candour or frankness in relation to the presentation of the facts and the presentation of the law. The duty of candour has those two elements, really. It requires practitioners to be open, frank and honest, candid about the facts of the case. So not to try and put the facts into a light that suits their client the best. But they also need to be open, honest, candid, complete about the law in front of the court. So lawyers have a duty to ensure that all relevant law, including the law that might not be in the client's favour, is correctly applied. So what is required is respect for the procedural requirements of the system, which basically requires, or prevents, I should say, I think requires you to avoid tactics that deliberately and unfairly obfuscate or frustrate the pursuit of justice. So those kind of tactics could be suppression or distortion of the truth, or otherwise misleading the court. Lawyers must not mislead the court as to what the law is, but they can do, and they should do, what they can to ensure that the law is applied correctly to the case. So this is this kind of fine line, and this is one of the reasons why you get so many RAC style, IRAC style problem cases in law school, because you need to apply the law to these facts, which often means that you're looking for ways to distinguish on the facts in order to support your client's particular point of view. Ultimately, though, the fundamental duty is you must not misrepresent what the law says to a court or to a tribunal. In the more recent cases, it looks like the court is taking a particularly dim view of conduct that has any kind of dishonesty attached to it. So have a look at Legal Services Commissioner and Mullins, and the Legal Practitioners Complaints Committee and Fleming. These are both instances of cases where there was some kind of deception by omission. Lawyers need to be really careful not to align themselves so closely with their client that they become a party to misleading the court. Clients won't always tell you the truth, and clients, they're all a bit like Bruce Willis. They see what they want to see. They hear what they want to see. Your job is to be like the little boy and stand back and see that bigger picture, to use your sixth sense, if you will. Have a look at Rule 20 of the Australian Solicitor Conduct Rules, which sets out the process that you need to follow if you become aware that your client has not been totally forthcoming in terms of the facts, because the duty that you have to the court is paramount. So Rule 20.3 in particular, it relates to the circumstance where you become aware that your client intends not to follow a court order. I'll be back. A lawyer cannot advise their client, or indeed any third party, to disobey a court order or to give any kind of tacit encouragement or approval for disobeying a court order. If your client discloses an intention to disobey a court order, you need to advise against doing that and warn of the dangers. So the last thing that you need to be doing is advising how to carry out or to conceal your course of action or something like that. Even so, you cannot inform the court or your opponent of the client's intention unless you've been previously authorised by the client or that you believe on reasonable grounds that the client's conduct constitutes a threat to any person's safety, including the client's safety. Okay, so coming back to the question of documents, a lawyer must not knowingly submit a false document to the court. They must not, therefore, be a party to an affidavit that contains any untruth or misleading statement. And this is a point that was elaborated by Justice Ip in Kyle and the Legal Practitioners Complaints Committee, which is a case that was mentioned on an earlier slide with a citation. What's really important here is, and I've tried on the slide for those of you playing along at home to emphasise it with bold and then colour, but ultimately the full quote there is from Justice Ip is instructive, but really what I want to highlight is that if a lawyer discovers that the witness statement which has been served is incorrect, the lawyer must inform the other parties immediately. And that rule reflects the duties that lawyers in Australia have to the court. So not everything is a straight out lie, though, is it? Something that is completely untrue. What happens when you've got kind of a half truth, I guess? So Meek and Fleming is a really good example of this, probably the key case in this area. And essentially it tells us that lawyers need to eschew statements or conduct that is a half-truth or that might otherwise leave the court with an incorrect impression, which is, let's face it, another word for a misleading the court. So in Meek and Fleming, the plaintiff claimed damages for assault and wrongful imprisonment against the defendant, who was a chief inspector of police. After the proceedings were initiated, but before the trial, the defendant was actually demoted to station sergeant, essentially because he deceived the court in a completely unrelated matter. So the defendant's counsel decided not to tell the court about the demotion, and let the judge and the opponent refer to the client as inspector or chief inspector throughout the proceedings. Ultimately, this resulted in a mistrial, and a not guilty verdict could not stand in circumstances where the court had been misled into thinking the defendant had an unblemished reputation. And so, again, the quote on the slide from Holroyd Pierce, so Lord Justice Holroyd Pierce, I should say, the duty to the court here was unwarrantably subordinated to the duty to the client. And again, hierarchy of duties, duty to the court, including the duty not to mislead the court, comes first. As a consequence, sort of true but not really true, not close enough. Ex parte application. So you know what an ex parte application is. Ex parte is Latin for one party, and we use it to refer to motions, hearings, orders, or cases where one party acts or applies for an order in the absence of the other party. So they're kind of a unique type of application in an adversarial system, which usually has both parties fighting for their own interests. So because of this, there's a extra special, we like to say S special, but I think that's not really plain language anymore, an extra special candour that's required on behalf of applicants to avoid the abuse of court process. So in order to fulfill this duty, an ex parte applicant needs to supply the place of the absent party to the extent of bringing forward all material facts which that party would presumably have brought in their defence to that application. So lawyers on an ex parte application must, as a consequence, display the utmost fairness and good faith and see all relevant matters for and against the application are brought to the court's attention. This behaviour is, and I'm quoting here from ERS Engines and Wilson, this behaviour is viewed not only as contrary to a lawyer's duty to the court, but also contrary to duties owed to fellow lawyers. So this behaviour here, I'm referring to circumstances when lawyers don't disclose the full facts of the matter or all of the circumstances that would be relevant if somebody were arguing against the application. The last thing that I want to talk about in this video is part of our duty to the court is a duty not to illegitimately destroy or remove documents. Now, there's quite a bit about this on Canvas, and I don't want to spend a lot of time talking through the details here. The key case is the 2002 Victoria Supreme Court case of McCabe and British American Tobacco. This is a case that we've mentioned earlier in the context of that the zealous advocate, and it's dealt with in some depth in Parker and Evans, if you want to sort of read a little bit more widely, although the section in Parker and Evans that deals with it, I suspect, is not actually one of the case studies that's relevant here. Ultimately, lawyers cannot be parties to illegitimate destruction or removal of documents. A client may be tempted to destroy documents that don't support their case. This happens all the time, but lawyers need to ensure that they don't advise removing or destroying documents if there's a prospect that these could be relevant to prospective or existing litigation. So following the McCabe case, which essentially involved a law firm, Clayton Utz, advising a client, British American Tobacco, to destroy or remove documentation that could be relevant to litigation. Victorian Parliament made it a crime, punishable by fine or imprisonment, or both, for a person, including a lawyer, to wrongfully destroy documents. So this is really important, that in addition to our general duties not to mislead and destroy mislead the court, we also have, there is a criminal prohibition against the illegitimate destruction or removal of documents. Enjoy your reading in this area. There's lots of juicy cases to get yourselves into. And remember my advice in the earlier video, just keep thinking about how this stuff works in practice. And I think you'll be able to synthesize a great deal more and get a great deal more out of it. I'll see you in the next video when we will talk about dealing with witnesses.